Okay, I'm going to start it. See what happens.
Hi, Lori.
Hi. How are
So
you?
I'm good. So I'm Paul Moore. I'm going to be the moderator for your breakout. So we have to do some technical stuff real quick here and get our names fixed and all that. So give me 5 seconds to work on that.
Sure.
Okay, so let's see. That's me. So let me change my name. Okay. Okay, so I think you actually have to change your own name. So if you go to participants at the bottom there on the Zoom call,
Okay.
and then you click on, like, hover over your name, which is like host 500 right now, it'll say more.
Okay.
And then it just says rename, and then just type in your name. Awesome, great. Oh, wait, typo.
I did it wrong?
No, I think it's Miller, right?
Millet.
No, it's Millet. Oh my gosh, they had the right, oh my gosh, is that, okay, never mind. I have the wrong notes here. My apologies, I'm glad we're talking now. Okay. I guess that leads me to my next question. I want to introduce you. Do you just want me to introduce you first and last name, or Mrs. or Miss? How do you prefer to be introduced?
First and last name is fine.
Okay.
Yeah, and everybody can call me Lori. I know I'm not into that formal stuff.
Okay, I hear you there. Yeah, I usually just go by Paul. I don't, Mr. Moore. I was in education for a long time, and it was just always so awkward. So
It is, and it makes me feel old.
yeah, I hear you there. So okay, let's see. So our session doesn't begin for a little while, so we got time to kind of prepare here. So what I'm going to do is just kind of be hanging out in the background. I'll introduce you, and then I'll mute myself so yours is the only video showing, and I'll kind of moderate chat. And then when you're done giving your presentation, I will then just dictate the questions to you, like ask them for the chat to you.
Good, that's good. Okay. Yeah, I tried to do one of these and moderate or do the chats myself. It was very distracting.
Yeah, that's why each of these sessions have, like, that's why all of them have a moderator like me, just to kind of take care of that. So you can focus on your presentation and getting that information to people, and I'll worry about the technical stuff.
Cool. I need someone else to worry about the technical stuff for sure.
Okay.
You need to test the sharing of the slides.
Well, yes, we should. That is my wonderful assistant. She is
she doesn't like to be on camera.
No, she doesn't. She even refused to upload her picture.
What now?
She refused to upload her picture. She's in my. That's how much she hates being on camera.
Okay. It's not my personal favorite thing either, but I've had to get used to it since COVID began. So let me change my background. I'm supposed to have we have a specific background for me anyways.
So you want to do that and then I'll share my screen, or
yeah, let me make sure I get my part straight, and then you can share your screen. We'll make sure that works. Okay, there we go.
Oh, very nice.
Okay. So you didn't need to have a green screen behind you?
No, so Zoom, it's a little weird because you can see it kind of cuts off parts of me, but
Zoom allows you to do it without a green screen.
Yeah, it kind of trims around where it thinks your body lines are, but it can get a little strange, as you can see with like my hand. so it's best to just keep your arms down, and yeah. So, but yeah,
you can tell everybody you're like 30 pounds lighter, and it's just,
right. It's like, oh, it's like the camera literally cut 5 pounds off. We're good. I've been totally keeping in shape during this. All right, go ahead and try your presentation. We'll make sure that works.
All right, share screen.
All right, nice.
He sees it, but you don't. Oh, that's how
here it is. Yeah, this is how I see it. And then I have to go to slideshow.
Wait.
Design,
There's slideshow.
Where's slideshow, Kim?
Isn't that what
you want? Yes, for heaven's sake. Thank you. See, you should be doing this.
No, I'm just
from beginning, from current slide. Okay.
Okay, oh, that looks good. Yeah. Let me see how it looks on the, minimize this.
Hey, Denise.
Hi,
Hey,
just
I
check.
want to get some of those Alzheimer's face masks.
You'll actually get one because you registered.
Yep. Oh, hi, Denise.
Hi, Paul. Yeah,
Exciting. Okay.
Yeah, we'll get you one out. Make sure we get you one out.
Okay.
So how come that's not showing?
Okay, I just wanted to check on you. You feeling good, Paul?
I think we're fine. She's practicing her presentation to make sure that comes through now. I've got my name changed. She has her name changed.
Okay.
And I think we're looking good. Hopefully, everything's going to be good.
Oh, hold on one second. I think we're broadcasting.
We shouldn't. I didn't hit start meeting.
Oh, okay. You have start meeting?
No, I have not hit start meeting. Hang on. Let me. Oh, maybe did I?
I think
Oh,
so.
maybe I did.
Oh, start webinar? Okay.
I don't think I hit. I know I didn't hit start webinar, but I don't even see the option now, so that kind of scares me a bit.
Yeah, so we are. That's okay. Hello, everybody. Just stand by, and we'll get started promptly at 10. Okay.
Okay.
Yeah, who?
How many participants? Well, it still only says 2 up there.
Yeah, it just says 2 people.
That would be you 2.
Yeah, there's supposed to be a start webinar button though, and I don't.
Well, I think I hit that in the beginning because
Oh, you hit the start webinar button when you got on?
I
Okay.
think I did. Yeah.
And that's what happened. So that just makes it live. So we're recording right now.
Oh, well, that's kind of a bummer. Okay.
That's okay. It's okay. So anyways, we know the screen share works. We're good. We're live. We'll just I'll mute my video for now until it's time to start. That way people don't think we're starting early or something.
Okay.
Lori, do you have the volume on your phone?
It's muted.
That one?
No,
if it
how do I
rings-
turn this off?
Well, I don't know about doing that.
There's a mute button in the bottom left over the microphone. You can just click on it.
Oh, you know what? I don't have, what happened here? I don't have the little toolbar. See, this is why we start early.
Yeah.
Because I normally have that little toolbar. What happened? Where did it go? Oops. Oh, there it is. Okay,
So it's
so
on your
it's on the
screen.
other side. Well, how do I get it on this side? It won't move.
Maybe it stays there then.
Well, I don't want it over there. I want it over here. Stupid thing. Get over here.
I'm going to mute it until you figure it out. Just give me a thumbs up once you figure it out.
Okay, thank
Okay.
you.
Yep.
I wonder if I can find this volume.
Don't like technology.
So blessing and a curse.
Yeah, no, that's right. I'm unmuted.
That's okay. It's
Yes, it is a blessing and a curse. I had to get a new phone and everything's different and I'm all flustered every time I go to try and use it. Ugh,
I have definitely been there.
man.
I mean, I think I have an Apple phone and they just did the update on it and everything's different just with the update. So
That's right. That's right. Now it's iOS 14 or something and everything. Not only does everything look different because it's a new phone, but it all looks different because it's a new operating system.
Yeah, and so like calls come in differently. They're like in a tiny box now instead of going to a full screen, and it's a little odd. So
Yeah, and my home button is gone. I
right.
don't have, so that's a big adjustment. But you know, the old one quit ringing, so
You kind of have to upgrade.
okay. Oh, good work, Kim. Kim was able to turn the phones off in my office.
Oh, excellent.
I know, she is really handy.
Wish I had an assistant or even a friend right now, just stuck in my office by myself.
Yeah, no, I could not do this without her. I tell everybody, you know, she runs the place. I am just a figurehead. It is totally true. Totally true.
Okay, got a few minutes here and then we'll begin. And then I'll turn my video camera on and introduce you, and then you can give your presentation. How long is your presentation roughly?
I've got it tentatively timed for 45, 50 minutes, so there's time for questions.
Okay, yeah, try to keep it there so we can have at least like a 5 to 10 minute question time.
Are you going to have people hold the questions till the end, or
They can ask them what they can ask them whenever they want, and I'll
Okay.
keep tabs of them, and then I'll bring them up when it's question time, so we don't that way. So I'll just let everybody know during my introduction that's what we're going to do.
Okay.
All right.
Okay, one more sip of tea before we go on air. Why did my screen sharing pause? Well, that's not good. I don't want my screen sharing paused. Oh no.
You could probably stop it and then restart it.
Okay, there it goes.
Yeah.
All right. See?
We're going to get through this. It's going to be great.
Every time I try and move a slide, it pauses the share.
Interesting.
Oh.
I can see that you're going through it now.
Okay, there we go. Okay.
That'll work. Okay.
All right. Yeah, I'm glad you're here to back me up, man.
Yeah, I got you. I'm here. I mean, I'll do the best I can anyways. So, all right. So it looks like we're at 10 o'clock. So I'm going to unmute my video and do the introduction to get this started. So hello, everybody. Welcome to our 10 a.m. breakout session. I'm Paul Moore. I'm the Southeast Regional Manager for the Alzheimer's Association New Mexico chapter, and I'm going to be moderating chat and relaying questions to Lori during the presentation. So just so you know how questions work, you can ask them at any time. So if Lori says something and you're like, ooh, I want to know more, just ask your question right away. I'll write it down. And then when we have the question and answer session at the end, I'll relay your questions to Lori. It'll also help us if there's any duplicate questions, and I'll just put up on a higher priority if multiple people are asking similar questions. So this session is going over the incredibly important topic of what to do if there is no decision maker for your client. And to address this topic, I'm honored today to be able to introduce Lori Millet from Albuquerque Elder Law. Lori has both her Juris Doctor and her Master of Laws in Elder Law. And with that, I'm going to hand it over to Lori for her presentation.
Good morning. I have to start with saying I would much rather do this in person because I am technologically challenged. But nonetheless, Paul's going to be my backup man, and we're going to get through it. I know there are times when you cannot get someone to be responsive to you regarding your decisions that need to be made for your patient or your client. And it's a tough situation to be in. So the first thing that you need to consider is whether or not anyone has been given authority to make decisions. And the very first document that I want you to look for is a power of attorney. There are 3 possible powers of attorney that you could have, or your resident or patient could have signed. The first one is a financial power of attorney. The second one is a healthcare or medical power of attorney. And the third one is a mental health power of attorney. And those are not very common. It is possible to have the mental health power folded into the healthcare or medical power of attorney. So you may just be looking for 2. The reason that I said there were 3 possibilities is because there are 3 different sets of laws that govern these powers of attorney. So the next thing I want you to look at is whether or not the power of attorney is effective immediately. Hopefully it is, because if it's only effective upon the resident or the patient's incapacity, which is also called springing, then you're going to have a harder time getting someone to make a decision. The document could require a determination of incapacity in a few different ways. It could be a physician. It could specify physician's assistant, a nurse, but it most commonly specifies a physician to certify incapacity. And sometimes it requires 2 doctors' certifications. And even worse, some documents require that there are 2 notarized doctor's statements. And especially right now in the middle of the pandemic, it is going to be extra difficult to get a physician to sign a notarized statement attesting to the principal who is your resident or your patient, the incapacity, so you can move forward. But without those doctor's certifications, the agent has no authority to make decisions. So if you own a residential home or some other kind of facility, or you're a geriatric care manager or a guardian, I want you to make sure that the agent has the authority. And guardians, you need to look at the court order that appointed you, and I'm going to get to that in a little bit. The other document that may be relevant for you to look at is whether or not there is a trust. But keep in mind that a trustee only has authority over property that is actually titled in the name of the trust. And so that isn't going to be as helpful for you. So let's talk about the financial power of attorney. Please do not assume that all financial powers of attorney are the same, because they are not. Not only do they vary with the language, but they vary in accordance with what you're supposed to use under New Mexico state law. The law changed pretty drastically in the late 2000s. And so unfortunately, some powers of attorney that I see are still done under old law. We have the Uniform Power of Attorney Act, which means that there is in our state, it means there's a statutory form and there should not be the ability or process to make medical decisions. So if it's done under the old law, the power of attorney is still good, but it's not as comprehensive as the current statutory form, which can also be amended. In other words, things taken out of or things added to it to give the agent more authority or less authority. So because the old law gave the power of attorney or the agent the ability to make medical decisions, there wasn't a whole lot of guidance about what medical decisions could be made. It was very generic language. So hopefully you have a separate healthcare power of attorney. So what if your agent is not responsive to your phone calls? They're not calling you back. Is there an alternate that is named or a backup, a successor? And so most documents say if the first agent is unavailable, then the alternate or the second agent can make decisions. And if the second agent is not available, then the third agent can make decisions. There's no limit on how many alternate agents can be named in a document, but it's really unusual to see more than 3 altogether. And keep in mind that even spouses cannot access accounts in the name of the other spouse, even if it's community property. So for example, retirement accounts like IRAs and 401ks, even though those are technically community property under New Mexico law, because the account is just in the one spouse's name, the other spouse cannot touch it without a power of attorney. So a conservatorship would be required. And this is going to matter a lot if you need someone to sign an admissions contract or assume liability or responsibility for payment of your bill. If there is no financial power of attorney, then there is no decision-making tree. That's what I call it. That's not an official term. But in the healthcare law, we have a default decision-making tree, but there is no such thing for financial decisions. Joint owners on bank accounts have no authority to sign contracts on behalf of the other joint owner. And they should not be deciding what to do with the joint owner's funds. So you're going to need a conservatorship. And just to make sure everyone understands the difference, because I'm not sure who is in the audience, conservatorship is like a guardian of the money or the property. So healthcare or medical power of attorney, they're also called advance directives. These documents are governed by the Uniform Healthcare Decisions Act. And only a handful of states have this statute. It's 10, no more than 10. So New Mexico law is very, very different than our neighboring states' law. And the statute says that the patient or resident can give oral instructions with respect to who can make decisions on their behalf. Note, there is no parallel provision like that for financial power of attorney. But in both cases, the principal, your resident or patient, has to have capacity to name someone to make their decisions for them, whether they're signing a written document like a financial power of attorney, or they are signing a medical power of attorney, or they are giving the provider instructions as to who can make medical decisions on their behalf. And so that can get a little tricky, as you might imagine, particularly with someone who's got the ebb and flow of capacity due to dementia. So what if you don't have a medical power of attorney? Who gets to make the decisions? This is a decision-making tree that I was referring to earlier. The people who make decisions in accordance with the decision-making tree are called surrogates under the statute. But before a surrogate can make decisions for your patient or your resident, there have to be 2 certified or qualified healthcare professionals to attest to the person not having the ability to make their own decisions. Qualified healthcare professionals are defined in the statute as a physician, a physician's assistant, a nurse practitioner, a nurse, a psychologist, or even a social worker. So let me make sure you understand. Physician, which could be an MD or a DO, a physician's assistant, nurse practitioner, nurse, psychologist, or social worker. Sometimes none of those other professionals are available, and it will fall to the social worker to make a determination as to whether or not your patient has capacity. And the social worker should really be trained in that area. Now, I'm not a social worker by trade, but I know that social workers do have different levels of training. So if you work in a facility, make sure that the social worker you have on staff has the kind of training to be able to assess someone's capacity or incapacity. Then, let's say you get those 2 statements. Who's going to make the decision? The statute says any member of a class of the patient's family who is reasonably available. Now, what the heck does reasonably available even mean? And this is a quote from the statute. Can be contacted without undue effort and is willing and able to act in a timely manner, considering the urgency of the patient's health care needs. That is really loosey-goosey, and I think it is loosey-goosey on purpose. Loosey-goosey is also a legal term, by the way. No, not really. But it's wishy-washy because it's going to be up to whoever is trying to enlist the aid of the person who needs to make the decision. It's going to be up to maybe the house manager to figure out, well, what's reasonably available mean to me? And that's where it gets tricky because it is such a subjective standard. But that is literally what the statute says. So a house manager in this facility may think that if someone doesn't call them back in an hour, that's not reasonably available, whereas someone else may interpret that differently. So hopefully you see the dichotomy there and the potential problems that that can cause. So let's talk about the hierarchy of who can make these decisions. Of course, the spouse, unless they're legally separated from your patient or a petition for divorce has been filed. I have had the divorce scenario happen quite a few times, and it gets nerve-wracking, particularly if the patient of yours has been the one to file the divorce petition. The spouse who may not want the divorce doesn't understand and wants to continue to make those medical decisions and they cannot by statute. They cannot. Even if they are named in a written healthcare power of attorney, they cannot make those decisions. And in New Mexico, we also have the domestic partner category. And the quotations is a direct quote from the statute. Someone who's been in a long-term relationship with the person, it doesn't say life partner, but that is the term that comes to mind for me, or domestic partner, which is what I have in the slide. So if they're hanging themselves out to be like a married couple, whether they really are or not, that domestic partner gets to make decisions before any actual blood relatives. The next person or the next class of people in the hierarchy are adult children, and then parent, then adult sibling, and then a grandparent. Now, I want to emphasize some things that can go wrong here. But I'm going to go through the very last person who can make decisions on behalf of your resident. That is an adult who has exhibited special care and concern and who is familiar with the patient's personal values. That can be anybody. It could be a neighbor. It could be a friend. It cannot be someone who works at your facility, because that is tempting. That's a prohibited actor in accordance with the statute. So even though the house manager may know the resident really, really well, the house manager cannot make these decisions because they work for the facility that the resident is in. The only exception to that is if the person is related to the patient by blood or marriage. Now, keep in mind, surrogates have to make these decisions in accordance with what the patient's values are or any individual instructions they may have given. And remember, these instructions can be made orally. If there are no known instructions or the wishes are unknown to all of the players trying to take care of the patient, then the standard to be used is best interest. Okay? Now note, the hierarchy is by class of people. If more than one person wants to be a surrogate, then the majority rules. A disagreement among the people in the class means that all the lower priority classes are disqualified, and you're probably going to have to get a guardianship. So here's one example. Johnny is your resident. He's in a coma. He has no spouse, but he has 3 adult children. If 2 of the children want one kind of treatment administered to Johnny, but the other child disagrees, majority rules. These 2 children have the final say. If Johnny only has 2 children and no spouse or domestic partner, and the 2 children do not agree, then you've got a deadlock and you may need a guardianship. Now here I'm going to share a personal story that happened with my mother. My mom named me as her primary power of attorney with financial and medical. And my husband was the alternate. My brother was not named at all because he doesn't do well in a crisis. And my mother knew that. But she was very stubborn, and she would not agree to have any of her powers of attorney effective immediately. So what that meant was when my mother had a stroke and we were in the emergency room, we being my husband, my brother, and myself. The doctor said the lab test showed we had about 10 minutes left to administer the clot busting drug to reverse the effects of the stroke. But there was not enough time to have another doctor come down and certify as to my mother's incapacity. My brother was sobbing and he could not even speak to make a decision. So even though my husband and I were both there, I was the primary agent, my husband was the backup, we had no authority to give the doctor any instructions to give my mother the clot busting drug. So the doctor couldn't do anything. And my mother was in a nursing home for 8 years, totally paralyzed on the right side, classic aphasia, 2-person assist. I'm sure you all have seen it. So hopefully your patient has a medical power of attorney that is effective immediately. Now, we didn't have to get a guardianship of my mother because then it took me a few weeks, literally a few weeks, to get 2 doctors to sign notarized statements that she was incapacitated, but we were ultimately able to use the powers of attorney. But in that medical crisis, no one had the authority to act, so no treatment could be administered other than to make her comfortable. Then there's one more little snag that a lot of people are unaware of, even some guardians. Let's say your patient has a guardian and is merely making healthcare decisions for your resident or your patient. And then a healthcare agent comes forward. Who gets to make the decision? It's not the answer you might think. The agent does. The agent has the continuing authority to make medical decisions unless the order that appointed the guardian revokes the power of attorney. And I have the actual citation to that law in the PowerPoint. Now, nowadays, the courts will not enter an order that revokes a power of attorney to the extent it has healthcare wishes or end-of-life wishes in it. So in other words, the healthcare power of attorney may be revoked, but that is only as to the decision maker, not as to the actual decision that gets made. So what if there is a guardianship and conservatorship pending? I know this happens a lot. See if there is a temporary appointment. You have to read the order for guidance on this. If the order says that the temporary guardian can make any kind of medical decision, then the temporary guardian can do that. Or the temporary conservator. I will tell you that temporary conservators often have a difficult time getting a hold of bank accounts in order to get control of them, even if there has been evidence of exploitation. So the temporary conservator may be stymied to some extent because the bank or other financial institution will not cooperate with the temporary conservator. So then you may think, well, who gets to make the decisions? As you know, in a guardianship and conservatorship proceeding, there is a temporary appointment of a guardian ad litem, and that is an attorney who is appointed to represent the alleged incapacitated person. The guardian ad litem, though, really doesn't have the authority to make decisions. The guardian ad litem can get independent medical and/or psychological assessments, but that is only a power that is granted to allow the guardian ad litem to do the investigation before the hearing on whether or not a permanent guardian and conservator is appointed. So I want to make sure you understand some GALs may think that they can dive in there and make these decisions, but they do not have that authority by statute. It is very rare for a judge to want a guardian ad litem to get directly involved. What is more common and more practical is that the guardian ad litem, oh dear, does this mean my screens have not been advancing all this time? Paul?
Your presentation still shows what you're showing right now, so you're going through your slides as we speak.
Okay, so
Currently, I see you on the decision-making tree hierarchy.
Okay, so I apologize for the confusion. I have very nice slides, but apparently they weren't moving. So let me get to the slide that shows where I am right now. I'm talking about the guardian ad litem appointment. Here we go. So the guardian ad litem can request the temporary appointment of a guardian or a conservator, and that is the best way to go. The judges now, even in the outlying districts, are much less likely to grant an emergency appointment unless there are really, really extenuating circumstances. So it used to be that we could go get an emergency appointment based on the petitioner's word that it was needed. But now, because there has been so much abuse in the guardianship and conservatorship world, the judges frequently will not grant a temporary appointment until the guardian ad litem has done some investigation. And the guardian ad litem can say, Judge, I've looked into it as an independent third party, and yes, we need to have a temporary guardian and conservator appointed. The third kind of power of attorney that you should be looking for, or guidance that you should be looking for, are on mental health decisions. This is governed by yet another section of the statute, and there is even a statutory form in the mental health code. I have only seen a couple of those in the 21 years that I have been practicing, because the reality is the mentally ill person doesn't want to sign one, or they want to revoke it, and then you have to have proof that they're incapacitated, so they don't have the authority to revoke it, and it just doesn't work. For that reason, it is much more common for an institution to file for a treatment guardian. And mental health court, which is a separate division of district court, and then the treatment guardian can give the consent to administer the treatment for the person who needs the help. Because mental health court is a division of district court, it is only open on Monday through Friday. And it's not even open all day. It is very difficult to get an emergency hearing before a special commissioner. It's not a judge that hears these, it's a special commissioner, and then the special commissioner makes a recommendation to the judge, and the judge always signs off on it. My point in giving you all this detail is so that you understand going to mental health court is not quick. The other reason that you may have to go to mental health court is to file for an involuntary commitment. And that goes a little beyond the scope of what I think we're supposed to talk about today. It is also very common for probate code guardians to have mental health powers. I do that routinely, particularly if someone has dementia or a known diagnosis of some kind of mental illness, because people often end up in an emergency room because they have become combative or are exhibiting behaviors that they haven't done before, and they need to go to a Jerry unit or Jerry psych unit or a regular psych unit, depending on their age, to get stabilized. So the law does allow for probate code court-appointed guardians to have mental health authority. In that instance, if there has been a treatment guardian appointed beforehand, then that treatment guardian's appointment is superseded by the other court's appointment. So there's going to be some coordination that has to be done between the probate code court appointed guardian and the mental health court appointed treatment guardian, because a treatment guardian has no authority to make medical decisions at all. And it is very important to have, I believe, one person be in charge of all of those decisions, because sometimes whatever's happening medically affects whatever's happening with the person's mental health as well. The last document you may want to look for is a trust. Trusts are really not going to help you if you have a resident who lives in your facility and you need a contract for admission signed, unless the trustee is willing to take financial responsibility for that bill. But the trustee cannot bind the individual to the terms of the contract. So in other words, the trustee cannot promise that the resident is going to behave in a certain way. But the trustee can agree to pay the bill. And the trustee never has medical decision-making authority unless that same person is named in a medical power of attorney as well. So you want to look for powers of attorney first. You want to see if they are effective immediately or if they are only effective upon incapacity. If they're only effective upon incapacity, you need to check for the provisions of how that determination is made. Is it a physician? Is it a healthcare professional? Is it one provider? Is it two providers? Are they supposed to have their certifications notarized? All of those things vary from document to document. For the financial power of attorney, what do they actually have the authority to do? Do they have the ability to sign a contract on the person's behalf? Or do they just have the ability to sign checks, access bank accounts? That might be enough, but I would be uncomfortable having someone sign a contract for admission if they didn't have the specific authority to sign contracts in their power of attorney. Do they have the ability to bind your resident with respect to other decisions? Hopefully so. Otherwise, you may have to go get a conservatorship. On the medical side, does the person have a medical power of attorney? Is that effective immediately, or is it only effective upon incapacity? On the statutory form for healthcare powers of attorney, you have the option to choose either one. The statutory form, though, does not have the mental health powers in it. So you need to look at your healthcare power of attorney and see all the powers that are given to the person. And remember that those can only be revoked if the person has capacity. If they don't have capacity, they're just mad at their son or daughter and they don't want them to make decisions anymore, then they cannot make a revocation of that document. The power of attorney stands. If your resident has some mental health issues, does that healthcare power of attorney have the mental health powers in it? Is there a separate mental health power of attorney? Probably not, but there could be. And if your person has no medical power of attorney at all, then you're looking at that decision-making tree or hierarchy that I described before. The hierarchy gives classes of people, and the classes of people are the ones who make the decisions, and they make it as a group. So it means majority rules, and that can be a problem for you if they do not agree. So I'm going to go back to that tree, since you guys didn't get to see it before. A domestic partner can make those decisions. And let me tell you, that doesn't go over very well with the family a lot of the time. It is possible to have a family member want to go to court and fight over who gets the decisions. And I've had to do trials on those cases. It is very emotional. It's very, very difficult. So hopefully you will never find yourself in a position where you don't have the ability to do anything because everyone's fighting about who gets to make the decision. And keep in mind that for medical powers of attorney, the emphasis is on who makes the decisions, not what the decisions are. So I think that wraps up everything that I wanted to talk to you about today. It went a little quicker than I thought it would. So I would be happy to field whatever questions you may have.
Thank you so much, Lori. So we'll wait for some more questions to come in. There were a few that came in during your presentation. The first one was when you were talking about oral instructions that were given. How do you document oral instructions for legal purposes?
You document it by telling the primary provider, and then the primary provider is supposed to note it in the chart.
Okay.
That's it. Yeah.
All right. And then again, if she does not answer your question or I did not dictate it properly, please let me know in the chat. The next question goes back to what you were just talking about with the decision tree, the hierarchy. Where do grandchildren fit in, or at all? Like, how does that work as far as like the majority rule and things like that?
Grandchildren don't fit in.
Okay. Unless, well, okay, so hypothetically speaking, if the grandchildren are the only ones, say the parents, the siblings are their, how do I explain this? So the grandchildren are the only relatives remaining, right?
So the grandchild could fit into the category of an adult who has exhibited special care and concern for the patient. But they are not actually in the hierarchy that is in the statute. The last class of people that's in the statutory hierarchy are grandparents. But if there isn't anybody else around, then grandchildren could be shoehorned into the category of an adult who has exhibited special care and concern for the patient.
Okay, thank you. I think that answers it, and that was coming from Michelle. Yes, that did answer the question. Thank you. Any other questions? I know this is a very complicated topic, so if there's any clarity you need, please do ask.
Wow, I thought there'd be more than that.
I did too. Usually. So I guess I do have a question. So when it comes to medical power of attorney, right? And you said there's two types. There's mental and just general medical.
Yes.
How complicated is that to get done? And how would you get that if in fact the person was already had Alzheimer's or some form of dementia? How's that process then?
Oh, sure. So what you're asking me about are what are the legal standards for people to be able to sign powers of attorney?
Right.
And so there are 3 levels of capacity. The first one is the highest level, and that is the legal capacity to sign a power of attorney. And the reason that is the highest level is because there are so many financial consequences that come out of signing that power of attorney. So there are you need to have a provider attest to the person's ability to sign legal documents. So let's say, for example, you have someone who has just been diagnosed with Alzheimer's disease. So it's early on in the process, and they do have moments of clarity. The actual legal term of art is moment of lucidity. If they can understand in the moment that they are signing what the consequences of them granting that authority are, then they have capacity to sign. Now, as you might imagine, that is really difficult to ascertain, and lawyers are required to make sure that they believe in their heart of hearts that the client has the ability to sign that power of attorney, even if there's a doctor's letter that says they can't. So for example, I have Johnny come to my office. I have a letter from a doctor saying he has the legal capacity to sign, but when Johnny's in my office, he's not having a good day. He does not understand what I'm telling him. I cannot administer all of the neuropsychological testing, but I can assess what I think his abilities are in that moment. And if he doesn't get it, I cannot have him sign that power of attorney, even if Dr. Johnson says that he can, because he has to understand what he's signing in that moment. So provisions can be made, though, to optimize Johnny's ability to understand. You can do it in the morning before he might start sundowning. You can make sure that he hasn't had any pain medication. You can make sure that the lighting in the office where he is isn't too bright or too dim, and he can see and he feels comfortable. And make sure he can hear you. I have had clients where I have had to literally scream in their ear because they lost their hearing during World War II because they were manning those big guns during the war and they totally lost their hearing. And that's all okay. That's fine. You can do that. Whatever accommodations can be made are perfectly legal to do. And I think lawyers have an obligation to do that because the presumption of capacity should be maintained and accommodated to the extent possible. The second level of capacity is the capacity to sign a will or a trust. And that's not what we're talking about today, but I wanted you to understand that that's a mid-level. It's not the highest level like a lot of people might think. And the lowest bar to be able to sign is for a healthcare power of attorney. Essentially, someone just has to be able to say who they want to make their healthcare decisions and what special wishes they may have. So you've got the best shot at getting someone with dementia, for example, to sign a healthcare power of attorney, but maybe they can't sign a financial power of attorney. Okay?
Okay, so we have 3 questions that came in during that one.
Okay.
The first has to do with power of attorney. So just a clarification here. Does power of attorneys, the mental, financial, and medical, they all end upon expiration, correct?
They die with the patient.
Okay. Okay, and then we go into a will situation at that point.
Correct.
Okay, so that was one. The next question, somewhat related. So guardianship takes priority over power of attorney, but not temporary guardianship. How does that hierarchy work?
Okay, so a temporary guardian may have his powers limited by the court order. That's not typical though. That's why you've got to really read that court order, and I would contact the guardian ad litem if you have any questions as to what the temporary guardian's abilities are. So the temporary guardian may indeed have a disagreement with an agent. And so in that case, the guardian ad litem may have to get clarification for you with respect to what the guardian or conservator is able to do. When I do temporary guardian and conservator appointments, I try to anticipate whatever issues there are going to be. In other words, I just don't file those blindly. I try and talk to folks and really get the lay of the land first, so that if I see that there are going to be some issues, I can address those at the outset. The typical legal answer is, it depends. And I'm not trying to be obtuse. It does
Right.
depend. You've got to read.
And then I guess just it's kind of a good wrap-up question. Do you work or know any bilingual or biliterate elder law lawyers?
She retired.
Okay.
Corbin, yes, Corbin Hildebrandt. Corbin Hildebrandt is bilingual, so he could definitely help you if you want. I'll have my wonderful legal assistant look him up in the bar directory, and we can give his number out. I'm sure he won't mind. But he is an excellent attorney too, by the way. He's very thoughtful, very cautious. You know, he doesn't just dive into stuff recklessly. So I highly recommend him. And his first name is Corbin, and his last name is Hildebrandt, D as in dog, T, and his phone number is 998-6626. That's 998-6626.
Okay, let's see. And then one more question going back to when a patient expires. So when the patient dies, wills and trusts become the default?
Yes. If there's a trust, then the trust is going to kick in. If there is property that has not been titled in the name of the trust, then there's going to have to be a probate, probably.
Okay.
Not always, but probably. And I also want to just mention that if you've got a problematic situation where the family isn't willing to agree, then it may be helpful to do some kind of mediation to get everybody on the same page. It helps a lot sometimes, and sometimes people are just so doggone stubborn, they're never going to agree no matter how magically or skilled the mediator is. And the difference between a mediation and a facilitated family meeting is a mediation actually has the parties come to an agreement, whereas a facilitated family meeting, the facilitator can make some suggestions. But you got to be careful because you want to make sure that everybody has a buy-in. But that could be an option for some of these situations where there is disagreement among family.
Okay, I think this will be the last one, but on the topic of mediations, do you do mediations? And if not, do you have a recommendation?
I do mediations. I also do facilitated family meetings, and you don't have to use me. I can give you some recommendations. Just make sure that you have someone who has, or you choose someone who has a background in the subject knowledge. So in other words, if you need a guardianship mediator, choose someone who has at least a basic understanding of guardianship law. And I hope hopefully that's self-evident so that the mediator understands the issues and can help direct the parties to come to an agreement.
Okay, well, I think that's it. Thank you all for the great questions. Lori, thank you so much for sharing your knowledge with us. This is always, the legal part of it is always probably the most frustrating and confusing for the layperson.
Sure.
So I really appreciate you sharing your knowledge.
Too, Paul.
Well, that makes me feel a little better. Well, thank you everyone for coming to this presentation. We really appreciate it. We're going to end the webinar now. And Lori, there was a lot of people asking for your slides, so we'll need to take care of that kind of in the background.
That is no problem. I'm sorry about that. I'm technologically challenged. I did make that disclaimer in the beginning.
Yeah, you did, but we'll figure it out behind the scenes. And for those of you that need them, we'll find a way to get you the slides today. So thank you so much.
Thank you, everybody. Stop share. And